You bringing the family in?
I don't got nobody to watch them, so I like to children. I gotta do what I have to do. So
I know, but children shouldn't be here in the criminal district court to watch their parents have to deal with criminal problems. But I guess sometimes that's nothing we can do about it. I mean, an infant and a little child is here in court. That's their earliest memories of life. Yeah. Okay, John, help us out here. You're a good man. How can you pull out of this nosedive?
Oh, we're still working on trying to get a resolution in this case, Your Honor. This is I believe it's a DWI.
Is it one of the children? It was a DWI with the child passengers. Is that the little child that was in the passenger? Or
You said, right?
was that the passenger or was it this infant? How old is the infant?
He just made some.
At 3 months?
2 months.
2 months. Isn't a place for
Well,
all of this.
Reset out here. On to the next thing.
Well, what are you going to do today? It says an announcement.
And yes, Your Honor, we're still working on trying to get a resolution in this case.
Well,
We have a probation on the table, trying to see if we work something that may prevent a conviction for her. We just can't get it with her for this type of charge.
Right.
But that's also what we're trying to get to.
Who's the attorney on that?
Mr. Haggard.
Hey, Joe.
A few more weeks, yeah. And issues as a result of the conviction, which is.
Is one of these the complainant?
For the child in my car, yes.
What was John? Was there an analysis done? It's talking about intoxication here.
I'm looking, Judge. I don't know yet.
It says the defendant was intoxicated, so, and there was a wreck, and the 1-year-old was just in the car, loose. Is there a blood analysis or something that was done here?
I don't know. I'm looking. I don't have it on there.
What do you know?
I don't remember if there's blood tests or not. I know it was an accident and then my discovery up here. I don't have my laptop with me. I didn't read it today. I'm not being able to get on. It's more dependent on this record.
The BAC was 0.160, Your Honor.
There you go.
Thanks.
Twice the legal limit. Who takes care of the child when you're not around, ma'am?
Nobody.
Well, you know, you're gonna end up going to jail on this. Probably. I mean, it's mandatory.
Which time, yeah.
Yeah,
Well, it
for
depends
just
on how we-
unless it's dismissed or reduced. But under this charge, you're going to go to jail. At least for.
It's 20 days. Is it 20 days?
10.
Yeah, okay.
So you've got to start making arrangements. That doesn't keep you out. Somebody's got to take care of the two little children, but
That's one of the things we're trying to work on, to see if we
Uh-huh.
can. some kind of-
it's got to be, the children aren't going to go into jail with you.
Well, also if we can, there's other ways to resolve it, get around that. That's why I'm trying to.
What way was that? Under this charge?
Under that charge, right.
Okay.
No,
All right.
under a different
That's all right.
charge. You could use some other kind of charge like endangering a child, which is the same crime, but in the same elements.
I know, but these are bad facts.
Oh, yes.
Okay, all right.
That's why I did.
But
If it was easy-
the state can do what they want to do, but these are bad
Yeah.
facts.
And if they're easy facts that everybody had resolved, that's why it's taking a little longer to get the state to do something different. We might not get anything done different, but that's what we're trying to.
Okay, on, Kia Ballard, come on in. You just get a reset. Or,
30 days.
yes,
Yes, please.
it is. I've never heard of it. I've heard of Smith and Jones. No, that's the others. Anything can happen. What are we gonna do on Mr. Atia?
I guess, sir, essentially, I went over the offer. We are in
Yeah.
agreement. We are in agreement, Judge.
You want to dispose of it today?
Yes, sir.
Okay, can you fix it up and
Absolutely. I was just.
thank you, sir.
Yes, sir.
I see both of y'all had the same last name.
Yes, sir.
What are the odds? Sir,
Not related though.
not related
Yes,
though.
sir.
The background is what?
We're both Pakistani. Both,
Oh.
Yes, sir.
Oh, Kia Ali. Hey, Dr. Aziz is my doctor.
Oh, really? We know them.
Mohammed
Yes,
Aziz
yes, sir.
and his wonderful wife. Yeah, they're
Yes,
very
sir.
good friends.
We went to the same church.
Oh, do you?
Yes,
Oh,
we went to the same church. Yes. sir.
okay. Well, yes, wonderful, a good family friend of ours. Yeah, and he's my doctor. Yes.
Yes, sir.
Well, but welcome and shukriya. Thank you for being here. Dr. Aziz teaches me some words.
I'd see. Are here.
And an extra fee.
Hey, son.
I'm not gonna tell you the way is this. You speak like an Arab. Tells me that like an Arab. I don't know if that's a good thing. Okay, 23-41359 is called the state of Texas versus Robert Lee Stroud. Yes. Mhm. Yeah, I would be too. It's never, that's a terrible. Okay, you are here with Mr. West, your attorney, right? All right, in cause number 23-41359, you were indicted back in January of 2023 for the third-degree felony of evading arrest or detention with the use of a motor vehicle. And you pleaded guilty to that charge in January of last year, 2024. We placed you on 10 years deferred or unadjudicated probation. I think you went to the Safe P program, substance abuse felony punishment facility. And you were ordered to go there and complete the program. Apparently that was not accomplished. And on May of last year, a year ago, a motion to revoke unadjudicated probation was filed by the criminal district attorney's office. And this is the motion that we are going to be dealing with. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Sean, please.
Mr. Stroud, this motion to revoke unadjudicated probation in summary states And by the way, raise your right hand. Raise your right hand.
Oh, really, man.
Do you solemnly swear or affirm any statements you make will be the truth, the whole truth, and nothing but the truth? So help you God during this hearing.
I don't be Jesus, God. I don't want to talk to you.
All right. That's okay. Yes, that's affirmative. All right. This states that on January 25th, 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for this third-degree felony of evading arrest or detention with the use of a motor vehicle. Is that true? I'm sorry.
Yes,
It is true? Yes, sir. Okay. Allegation one, the only allegation here it states that you violated your probation by failing and refusing to participate in the substance abuse felony punishment program as ordered by the court in violation of condition 12 of your deferred or unadjudicated probation order. Is that true?
I don't see why it's called a punishment that we
Okay.
making us on the law, we doing the law.
Okay, have a seat. We're gonna have a hearing. He denies it.
Making up law.
You, sir,
I said, y'all keep making up law, that's the law, and I'm late.
let me ask you, John, is there something wrong? Do we need an examination or something?
He was just found
Because I said.
Your Honor, on
That he was
April,
incompetent.
April 11th,
And you-
from the Dunn Behavioral.
I still believe he's incompetent, but
Yeah.
the doctor says he's competent, so that's all I hear.
Yeah, well, I know, but he's rambling and is incoherent and it continues to rudely interrupt the court, which is against the rules. He's not following rules and he's mumbling and he seems incoherent. What do we want to do? Yes, you are, sir. When I speak, you have to stop or else you have to go back to the jail and you're put in detention. We don't want you to do that. Go ahead.
Your Honor, I don't believe he's competent, but the doctor's report and has ruled that he's competent, so the court does not.
Can you explain, is there any explanation you can make for the way he is acting now, if he is competent, for the record? We've got to have something in the record that supports something other than the way he is manifesting
Your Honor,
himself now.
I will say that every time I spoke to him, it's very similar to this, that it doesn't make a lot of sense. It's incoherent. He is not very easy to communicate with. I still do not believe he's competent. And I know the doctor ruled that he is competent. I'm not a psychologist, don't have a degree in that, but you're not able to coherently understand what's going on.
I hear what you're saying, right, and the judge come on, like, just feel like guilty, I hear what you're saying, I feel I'm guilty. I hear you, Lord, yeah, it's just the jail, it ain't me, man. You stay at the jail right now, telling you like you educated. I'm educated, you ain't never go, man. I'll let you speak over me.
Don't be rude. Don't be rude. Don't be rude. Hold on. Don't say a word. This court's reading something. You'll be able to speak here in just a moment, sir. Thank you. Are you taking your medicine? They're giving you medicine?
Take no medicine for the word for BC powder.
They're not giving
You have a little bit coming straight off.
John, he's mumbling. I don't understand it. It's like in a different language. Is he taking his medicine?
He said no.
Is he being administered medicine?
I don't know if they're doing it or not, but he's not, according to him, he's only taking BC powder. Is the only thing he takes. That's all he needs.
BC, that's for indigestion?
It's kind of like a general.
I think for headache.
Yeah, it's just kind of like a Tylenol.
See, it says here in this evaluation, and I'm looking at a report dated April 15th, 2025. A month ago, it was prepared by the University of Texas Health Center at Houston. And this is an evaluation of the defendant by Dr. Signed by Dr. Daniel Doyle, Chief Operating Officer. It was a very lengthy report of a report of competency and attending physician's report of the defendant, signed by a psychiatrist, Nicola Polizzato, Polizzotto. And this report consists of 13 pages of single space text of the result of the analysis of the defendant and the opinion and recommendation summary on the last page of this report in the portion called Attending Physician's Report of Patient's Progress. The treatment team's opinion of Mr. Stroud is he has achieved maximum benefit from inpatient hospitalization, and he should be returned to court as he is competent to stand trial. It should be noted at the time, no known prior history is noted, but at the Jefferson County Jail, while he was there before they had analyzed it, the defendant was described to be disorganized and internally preoccupied. Well, that's what he's doing right now. He was not started on medications and presented at DCB with no sign of improvement, appearing also grandiose. At first trial with Haldol, up to 30 milligrams daily led to just a partial response, and similarly, olanzapine up to 30 milligrams daily also led to improvement, but some degree of disorganized persisted. He entered Safe P and began his treatment, but quit it on April 22nd, 24. So he was reincarcerated in May of 24. He was prescribed olanzapine 10 milligrams, but it seems he was most recently non-compliant with taking his medicine because he seems disorganized and internally preoccupied, like he is now here. Given his history of partial response with failure of olanzapine, it was attempted to prescribe a combination of olanzapine up to 30 milligrams daily and Invega up to 12 milligrams. Again, disorganization with illogical, nonsensical statements or neologisms appeared difficult to treat. However, he made further improvement over what observed before, and while some disorganization persists, he is now able to communicate relevantly. His behavior seems appropriate, and he has displayed fair participation in the program. He has clear benefit from current medications. It is strongly recommended he continues to take psychotropic medications as prescribed. Currently, he is not a threat to himself or others, and a civil commitment is not being pursued. It seems like the issue is ensuring that his medication is taken. Are you taking the medication?
I'm taking the medication.
You're not taking any medication?
I don't take it. I don't take it. I don't want that in my body. I don't want that
Okay.
in my-
Did they give it to you though?
I take it at nighttime. I don't take it-
How do you take it?
I take it with water.
With water? Okay. All right.
Mm.
Okay.
Mm.
So back to this.
I ain't trying to-
back to this allegation, this states, Mr. Stroud, you refused to participate in the Safe P program as ordered. Is that true?
Yes, I ain't gonna tell you none of it.
You're not gonna do that? Are you pleading true to this
Yeah, I'm trying to get this straight.
voluntarily and because it is true?
Yeah,
Okay. Do you understand
yes, I understand.
that,
everything.
hold on, let me speak, that a knowing and voluntary plea of true, that is enough to a violation of program, probation. That is enough to grant this motion to revoke probation. Your probation could be revoked. You could now be found guilty and sentenced no less than 2 nor more than 10 years confinement in prison. Do you understand?
Should be time served for offense.
Do you understand what you're facing?
Yes, sir, yeah.
Because you've got a lot of time served. You got almost 700 days. Yeah, almost 2 years. Knowing that, knowing all of the consequences possible, do you insist on pleading true today like you've done? Okay. I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true here. Go ahead, John. What are you asking for?
Your Honor, we're asking for, just like you said, we're asking for credit for time served. He's already done.
What are you asking? Credit for time served? Give me a number.
2 years.
That you're asking for the minimum.
2 years.
of-
He's gonna have credit to cover that, and I think that would be a fair number based on his offense.
Just looking for a pre-sentence report really quickly. Does anybody have one? Dan? Which, I was just wondering what was criminal history is. What are you gonna do when you're released? Where are you gonna live?
Back in my behind Zooville by the mall.
Okay.
Go back over there.
Here's the criminal history.
And like you got an old folks like about 450 beats on. And
Okay, he's never been convicted. Looks like it was felony, huh? It's just been,
As far as I
he's
know,
been placed on probation for controlled substance violation and evading arrest, this one, and illegal possession of controlled substance twice. So he's been on 3 different deferred probations over from 2007 to 2022.
And he also had the, sorry, Your Honor.
Thank you. John, is that the fair with you?
Yes, that's what I want to get no conviction, no felony convictions. Different.
And then he's got a numerous misdemeanors,
Yeah.
but nothing, but they were only short terms in jail, resisting arrest. Okay.
So that's why I'm asking 2 years, because it's the kind of law.
All right.
It's not a.
What's- State,
State would recommend 4 years, Your Honor. Just 2 third-degree felonies. I mean, that's kind of still on the lower end, but I'm recommending a 4 year.
and Mr. Stroud, anything you'd like to say?
No, sir. Man.
Yes, sir.
Get to see what this love my world and pound it to the head, man. I mean, I got the head power and do it. I mean, for real.
Okay, all right.
And I think to translate a little bit about that, I think his issue is that he stays out of trouble, and on his probation, the only violation he does have is not going and refusing to commit safety. He hasn't committed new offenses or anything like that. So I would understand.
Before I assess a resolvement in this case, the thing is that what we want to do is fix the problems. And if Mr. Stroud does not take his medicine, then he's going to be right back into, we're going to revolving door and something's going to happen here. Here, it was evading arrest and detention. He was, on this case, that he's placed on probation on, he's operating a 4,000-pound missile around town.
Yeah,
Anybody feel safe with that?
I had in my car.
I understand, sir, but a vehicle, I know a vehicle has to be operated responsibly. Yes, sir. And- All right.
The other option is to continue him on probation.
What's that going to do?
Yeah,
for
so
us?
I don't think that'd be successful.
All right, here's what we're going to do. I'm going to find there is sufficient evidence supporting this motion to revoke unadjudicated probation. to grant it by a preponderance of the evidence or greater, as allegation one has been proven true, as the defendant has admitted, that he has failed to participate knowingly in this SAFE-P program, substance abuse felony punishment program, as ordered in violation of condition 12 of his deferred or unadjudicated probation order. Early in this case, the defendant pleaded guilty voluntarily. He was mentally competent to do so. He understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea to find him guilty beyond a reasonable doubt. I now find you, Mr. Stroud, guilty of this third-degree felony of evading arrest or detention with a motor vehicle that you were placed on probation on, based upon this motion to revoke unadjudicated probation hereby being granted today in this hearing. And you are found guilty beyond a reasonable doubt of that underlying charge that you were placed on probation for. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And you will be given credit for all time you have served, which is 2 years. So it sounds like you may be getting out here.
8 more months to go.
No, not necessarily. No, nothing. You may be getting out pretty quickly here because you're parolable, and very few people stay in prison, stay in a jail for the whole time. You get parole, and parole is generously given. So you might be released here shortly, but you're going to be given credit for at least 654 days, which is right at 2 years. Okay. Anything else? All right. Good luck. Good luck to you, sir. Thank you. And
I think that please ready.
hold on for a second. Hold on. Okay, yeah, come on up. Hey, we got 2 cases here.
Right.
We only did one. So we've got another. I was dealing with 41359, the evading arrest or detention. He was also on probation for 23 CR 525, right?
That's correct.
I thought we were released together. I thought that was.
No, there's a motion to revoke that says that was filed here in 23 CR 525, where you were placed on probation for 10 years on January 25th, 2024 for illegal possession of a controlled substance. What was this? Anybody know? This. Exactly. How much I know that. I need a copy of the indictment, please. It's not in the file all of a sudden. Okay, it's methamphetamine.
Methamphetamine 1.092 grams.
Okay. And in this motion, it alleges as well, Mr. Stroud, just like the other one, that you failed to participate in the substance abuse felony punishment program. And again, you're still under oath. Is that true in this case as well? Yes, sir. And you're pleading true voluntarily, knowingly, intelligently, and because it is true. Is that correct? All right. And again, I'm going to find, as the defendant is aware, that a voluntary and knowing plea of truth is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. I so find the defendant has failed to honor the conditions of probation, condition 12, as we found in 41359, and that is found by a preponderance of the evidence or greater. Thus, this motion to revoke unadjudicated probation as well, in this case, 23 CR 525, is hereby granted. And if nothing further to state by the parties, the court finds that is enough evidence to grant this motion to revoke probation. Your deferred unadjudicated probation in this case is hereby revoked. Earlier, you had pleaded guilty voluntarily to this case when we placed you on probation. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty at that time as well. And there was sufficient evidence supporting your plea to find you guilty beyond a reasonable doubt. Now that your probation is hereby revoked by the granting of this motion to revoke probation, in this case, your deferred or unadjudicated probation is revoked, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. In this case, these two sentences shall run concurrently together at the same time. Do you understand what has happened in this case, sir? All right. Good luck to you. Take your medicine.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.